What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta, owner of Rekieta Law, a small firm in central Minnesota. And I am coming to you today with a quick rundown on this Samcrac case. If you're not familiar, check out Samcrac's channel on YouTube. He restores cars. And what he has done is he has purchased a Domino's DXP pizza car that was totaled. He purchased it in from salvage for something like $500. And he restored it on his channel for his fans, as that's what he does on his channel for his fans. Domino's has come out with some pretty intense language demanding that he either get the vehicle back to them or he remove the mark. The trademark Domino's right up here, you can see, and the colors of the car obviously reflect Domino's. They've said they either want the car back or they want the car returned to its original state pre-Domino's pizza car. So just a standard body Chevrolet or something else. And they have sort of pushed the idea that there is legal action coming if he does not comply. So I want to take a real quick look at this. I am not going to spend a ton of time on this video. Not because it's not important, but because other guys have really covered the thorough breakdown of the case. Go check out Leonard French's video from Lawful Masses if you want a thorough breakdown. I'm going to keep this really short. At this point, Domino's, in my opinion, has made a bad move. Domino's is acting like a corporate bully with tons of money to sling around and has taken on a litigious sort of perspective. Thinking probably that a guy on YouTube who restores cars is either going to be not savvy enough or not have the resources to put up a valid fight, and they're probably looking to strong-arm him into making a deal that's against his interest, in their interest, and ensures that their trademark is not infringed. Brief point. It is important for Domino's to preserve their trademark. They have every right to do so. The question is not whether they have the right to preserve their trademark. The question is whether Samcrac's actions now or actions that he will take in the future are infringing. I will say this, from what I can tell of his actions now, they don't appear to infringe the trademark of Domino's at all. I'm not confused by this. I don't think that he's trying to sell me pizza. I don't think that he's engaged in any sort of business in competition with Domino's. Domino's is not in the car restoration business as far as I can tell. And I don't know that they have a YouTube channel where they restore cars or anything like that. He also doesn't seem to give the impression that Domino's is sponsoring him or is endorsing his channel or doing anything like that. He's made it very clear that he got this car from salvage. He restored it with his own work. He hasn't had Domino's representatives or Domino's fleet mechanics or anything on his show, as far as I know, to give the illusion that Domino's is somehow involved in this. So I don't think they have any sort of claim. It looks like they're involved in some pretty petty theft, chest thumping, and I hope Sam is able to defend his right to produce quality content that is unique, that is can expose people to this piece of American advertising art, and just do something kind of special that otherwise you wouldn't get to do. So, to talk really quickly about what a court case like this looks like, I'm going to go to this case, which is from the Orlando division. I'm not sure where Sam is precisely, but due to very brief internet research, I believe he is somewhere in Florida. So this is the type of decision, the type of court that we would see seeing his case, and they're going to use these same standards. They're national standards, so really you could use pretty much any court, but it's always good to pick a court that's close by. This case was also decided in 2015, so not very long ago. The long and short of this case is that some guy was using the Commodore's trademark. He's a singer in some sort of musical group, and he was using the Commodores, which is a music group from the late 70s, early 80s. He was using their name in his title, and they're arguing that it would cause confusion. The Commodores win this case. Mr. Thomas McClary, the defendant, does not win this case, and his use was found to be in violation of the trademark. It is a vastly different scenario than what Sam is in, but But the standards that they use are the same, and they have a very useful discussion about the two different types of trademark fair use. Going back to the article real quick, this is an article by Jalopnik, and they reached out to their legal expert, Steve Leto, who says that Domino's has a point and Sam is missing it. Fair use is a doctrine that protects someone from copyright violation claim, not a trademark violation claim. There is a copyright fair use doctrine, but there is also a different trademark fair use doctrine, and it comes into two different parts which are discussed here. First is classic fair use, which is basically, I'm not going to read through this because you can probably, I don't know if you can Google this case because this is from Westlaw, and I don't know if it's public or not. But you can pause the video if you really want to read the rundown of classic fair use. But what it basically is when a trademark involves a pretty generic term that is used to describe something, and then someone uses that term to describe their product, which may be similar or share a feature or look like the thing, and it makes logical sense to use the same term. So if your trademark is kind of vague and not a very specific trademark, then people can use your name. For example, Domino's, right, is a trademark. It is a trademark for a pizza chain, but if you're describing your product, which are dominoes, like the physical game dominoes, then you are not infringing upon Domino's trademark. You have a classic fair use sort of thing because you're describing your product, which are a set of dominoes. That is not you trying to cause confusion with the Domino's pizza brand. The Supreme Court has said that confusion can be caused and you can still win in these cases, which is a little bit interesting, but this isn't important here because this is not what's happening. This would not be the claim that Sam would likely raise against Domino's Pizza if he were taken to court. He would be doing something called nominative fair use, and that is, and I'll read the quote here because it's important, the use of another's trademark to identify not the defendant's goods or services, but the plaintiff's goods or services. So let me read that and replace defendant with Sam and plaintiff with Domino's, because that's how this would work. The use of Domino's trademark to identify not Sam's goods or services, but Domino's goods or services for the purpose of facilitating the sale of Sam's products. That's how that works. So in this case, here's how you look at it. Sam's product is his YouTube videos, his social media presence, whatever he does to earn income through that business venture. That is his product. Obviously, Domino's product would be, or Domino's good or service would involve their mark on this car. At one point, was it part of the Domino's delivery service? May have technically been a Domino's good when it was physically owned by Domino's. So that's the product they're looking for. Sam has to identify this vehicle as a Domino's vehicle to make his product interesting to his audience. If he's just restoring a Chevy, the base model Chevy, that might be interesting to some people, but what makes it more interesting, what makes it more unique, and what would separate his product from, say, another car restoration channel, for example, and give him a sort of competitive edge for this particular video, is the fact that it's this unique Domino's car that he found on salvage. That plays a huge part. So how the court looks at this is there's a three-part test. And the three-part test is first, and I'm going to replace defendants again with Sam, and I'm going to replace plaintiffs or any similes to that with Domino's so that it reads smoothly and we can apply it to this case. So the first prong, whether Sam's use of of Domino's mark is necessary to identify Domino's product, which would not be identifiable without use of the trademark. Yeah, absolutely he has to do this. Because, again, the interesting part of this video, the unique aspect of this video is that it is a Domino's pizza delivery car. It has some special features that are attached to it. It has unique branding and artwork on it. That's what makes it an interesting video beyond the normal car restoration video. That's why he did it, because it was this Domino's DXP delivery car. Okay? So, is Sam's use of the Domino's trademark necessary to identify it? Yes, absolutely. Prong 2, whether Sam used more of Domino's mark than reasonably necessary to identify the product or service. So does he use any more of Domino's trademark than necessary to identify the Domino's car? There's not much more to Domino's trademark than Domino's, the Domino itself and the Domino's name. I don't think he uses any more of the mark than necessary. He restores the car to its original condition that it would have been in while in the Domino's fleet. Again, that's what's interesting, because this is a driving service vehicle that is also a uniquely created advertisement. It has a cool, like, pizza oven warmer on the side that sets it apart from other cars. Finally, whether Sam's conduct or language reflects the true and accurate relationship between Domino's and Sam's products or services without suggesting that it is sponsored or endorsed by Domino's. And to my knowledge, Sam has not been put his audience or anyone else under any illusion that Domino's is involved in this at all. He has disclaimers in his video's descriptions that say that Domino's is not sponsoring or affiliated with his channel. He does not bring on Domino's Pizza. He's not dressed like a Domino's guy. He doesn't bring on a Domino's fleet mechanic or anything like that. He's not delivering pizzas. He's not doing any of these things currently that would cause people to confuse the idea that he's doing something like on behalf of Domino's or with Domino's permission or sponsorship. That's not happening. As far as I can tell, it looks like Sam is clear of the three-prong test. He has a nominative fair use defense. So the question is, what does he do at this point? Because fighting these things is expensive, it's time-consuming, there may be a better way to handle it, they may be able to settle out of court for some sort of agreement, so I don't know that this will go to court, but if it does, he at least has a good faith argument, and that is a great place to be. When you have a good faith argument for your claim, you at least know you're likely not going to get sanctioned, or you're not going to be found to be have a frivolous action or defense in court. You can go in there and confidently say, no, what I'm doing is protected speech under trademark fair use, and it is important that we protect that speech. It is important that we have the ability to identify other people's trademarks in our own products. It is important to do all of these things. So I hope Sam gets good advice of counsel. I hope he finds the resources to preserve his rights and fight for the rights of everybody out there. All right, guys. 15 minutes is about as long as I wanted to go. We're almost there, so let's wrap this up. The long and short, there are two types of fair use that are valid trademark fair uses. Again, it's that classic fair use and nominative fair use. Classic fair use is when a trademark is kind of vague and describes a particular thing that other people could describe. Domino's is a vague trademark in that respect, because if you're describing the Domino's game or a set of dominoes, then you're technically infringing on their mark, but you're not, because you're not trying to sell Domino's pizza by talking about the Domino's game. They're different things. So that's the classic fair use defense. Nominative fair use is where you definitely want to be identifying someone else's product, because the use of that other product is how you sell your product. The court uses the example of computer manufacturers saying this computer is compatible with either Microsoft or Apple operating systems, for example. Yeah, part of the sales of for example, Compaq, they're not even around anymore. Like a Hewlett-Packard computer is part of the ostensible desire would be that it runs Windows. So someone knows that if they buy this Hewlett-Packard computer, it says on there that it is Windows compatible, and they'll be able to run the software that they're familiar with or that they're looking for. Or, potentially they would not buy it because of that if they're trying to avoid Windows software. So labeling what type of other trademark is involved in this product is definitely something we should see. In Sam's case, it appears he is using the Domino's mark to denote the uniqueness of this particular restoration, and that's the selling part of his product. He's restoring this piece of basically advertising art. That's what people want to see. It's something that they're not going to really see anywhere else because it's hard to get your hands on one of these vehicles, even though he's managed to get his hands on two. Domino's doesn't typically sell them. You have to get them through some other method. In this case, like an insurance salvage sale is how he got it. So, hope you guys found this video interesting. I think Domino's is made a bad decision here in how they're handling this. And I hope Sam finds the resources to go ahead and fight for his right to keep doing what he does. The people who referred his situation to me seem to be fans and seem to think that he does a very good job. I'm going to check out some of his channels, check out some of his videos, even though fixing cars is not something I've ever been good at. It is something I am interested in, and I think that people putting together, driving advertising art and restoring it to what it was is also interesting to me. So I'm going to check it out. You guys should check it out as well. And again, if you want a more full breakdown of sort of the legal case and the situation so far, check out Leonard French's video on the lawful masses. He does a really good job breaking it down. So thanks a lot for watching. Hope you found this video informative, and have a glass of whiskey and have a good night. Peace.